minimize your case claims when insurance companies use computer software while reviewing your claim. We're joined today by California trial lawyer Mark C. Blaine, who specializes in personal injury law in downtown San Diego. Mark is also the co-author of the best-selling book, Wolf in Sheep's Clothing. And in today's program, we've been talking about the ways that insurance companies use computer software to determine your case amount. And in part 3, we're going to talk specifically about how claims adjusters implement it in their daily routine. So, Mark, we're going to turn our attention to the insurance companies and the claims adjusters that are using this software program. So what is their role first in the entire claims process, and then how do they use the software in their daily activities?
Sure. Interestingly, the insurance industry has spent very little time training its claims adjusters on this computer program. Usually it's 1 to 2 days of formal training, if that. The Colossus computer program has over 10,600 value drivers to drive the program, and the insurance industry, I believe, has intentionally kept the claims personnel ignorant to all the specific manipulations of the computer program. Now, balance this with the reality that most claims adjusters have approximately 150 to 200 injury files at any one time. The adjusters are trained to look for ICD-9 codes in their files. I mean, it's a lot of work for an adjuster to do. They have to look also for the types of medical care, the duration of all complaints and symptoms to input the data into the Colossus computer program. This includes impairment when warranted and properly documented by the doctors. At the same time, the attorney has to make sure all the medical evidence is being properly reviewed and accepted by the claims adjuster in order to trigger the value drivers on a given claim. The claims adjusters can only use Colossus on certain types of injuries, like injuries from a car accident. That's the most common. However, interestingly, there are 7 types of injuries that they don't use Colossus to review a case. And then if you'd like, Greg, I can kind of go through those 7 really quick.
Number one, I'd love for you to share that. Go for it.
Absolutely. Number 1 is severe brain damage. They don't use Colossus for it. Number 2 is dental trauma. They don't use Colossus for that, except if it's TMJ, which is a jaw joint injury. For number 3, they don't use it for severe spinal cord damage that involves paralysis. They don't use it for death claims. They don't use it for disfigurement injuries like scarring and the like. They don't use it for dog bite claims, and they don't use it for low property damage car accident claims, also known as MISC claims, which stands for minor impact soft tissue. So these 7 categories limit what the claims adjuster can do with Colossus, but every other injury out there is fair game for them.
Now, claims adjusters, and you kind of briefly touched on it, that they're only maybe trained for a day, maybe 2 days at the most about this. Now, using the software is only one part of their job. Now, they're busy doing other things as well, so they might not be 100% proficient in using the software. Is that kind of correct to assume?
Yeah, it is correct to assume, and they can only do a Colossus run or consultation, they call it, when they get supervisor approval, or if they've been with the company long enough, they can do it on their own discretion. But what I come to understand is that it costs the insurance company a lot of money to have the source code for Colossus, per year, and to run it per session. So they're real strict on when they implement the review on the computer, and that is why they only want to really do it when they have everything in front of them, because they don't want to go back to their supervisor and say they had to re-review or do a rerun on the Colossus program, because I believe it costs the insurance company more money. So they have to wait till they have everything in front of them, and then they do their Colossus review.
That's kind of an interesting point to know, and we're going to touch a little bit more on why the insurance companies pay these high dollars. But first, there's a term that you used in your chapter, and you called it tuning. Now, what does tuning mean, and is there any way to control it?
Yes, tuning is real interesting and important. Tuning refers to the assigned value Colossus gives a particular factor found in the medical chart notes of an injured person. This is controlled by the inherent programming of Colossus and what the insurance company sets it to given certain parameters. For example, depending on where an injury occurred would partly dictate the value of a case. What I mean by that is this. Zip codes are important. The zip codes of where an injury happened are used by the system because zip codes are used by the legal system to tell a lawyer which courthouse would be more likely a lawsuit would be filed if the lawsuit were needed. So this is important because different value ranges on certain injuries are given by juries in different parts of a given state. One example I use often is the Beverly Hills jury example. We find jury awards coming out of Beverly Hills courthouse often quite larger than, say, jury awards coming out of San Diego. And the reason for this is the concept or value of money is viewed quite differently in the jury pools in Beverly Hills than in, say, San Diego. So that is one parameter that is used by the tuning process, which are zip codes, because that's where the lawsuit, if one were going to be filed, it would be filed in the nearest courthouse in that zip code where the accident happened.
That's a really interesting concept, and it really does play a factor in the role of how this software takes everything into play. And going back to kind of the financial situation on the part of the insurance company is, why do you believe that insurance companies are paying high dollars to use this software and to run it on all their clients? And what do you feel is the overall benefit to the insurance company?
That's a great question. Some insurance companies spend $10 million a year to Computer Science Corporation, the owner of Colossus, just to have the right to license the source code to use Colossus in their injury claims review. They're spending big money because the program saves them big money in claims payout each year. Each dollar an insurance company saves in an injury claims payout is pure profit for them. The longer the doctors keep poorly documenting their patients' injuries, and the longer the lawyers fail to step up and educate themselves on arguing the value drivers we have been discussing today, the insurance industry will continue to win the battle for these settlement offers and using computer programs. Remember, the only thing that can take the power completely away from an insurance company in the injury claim is taking a claim to a jury trial and ask the jury for the value of the claim. However, this entails costs in the form of time and court expenses to the injured person. And the reality is trial is not really ready or needed for every injury case. Not every injury needs to be litigated, which is why I spend more time in the front end of my injury case with these computer programs to set me up for the back end when and if trial is ever needed.
And you kind of mentioned it, and I wanted to touch on two different pieces here, is how does your doctor and the medical care that you receive play a role in the data used in the software? And then I wanted to talk a little bit about human error. So how does human error kind of get played into the whole software equation?
Sure. Yes, human error in the form of the doctor not properly or effectively documenting an injury. You know, they don't teach doctors in medical school how to document an injury case for a computer program. There's no courses on it. But if the medical evidence is not documented properly, it receives no value, which is one of the main reasons that motivated me to co-author Wolf in Sheep's Clothing book. The doctor plays a pivotal role in a Colossus review because he or she is the foundation of the injury claim. This would be true if the claim went to a jury trial. The same doctor or doctors would be named as the medical experts on the case, and they would have to explain to the jury what the injuries were to my client. So to sum up on that question, Colossus recognizes essentially three types of doctors: the medical doctor, doctor of chiropractic, and a specialist, which is an ortho or neuro or the like. It does treat, depending on the doctor, it does treat some of the doctors differently. There is an inherent bias against the chiropractor in the program, but a lot of times when you use a chiropractor and you sandwich that chiropractor with a medical doctor, primary care physician, it actually adds more value to the chiropractor if the chiropractor were treating and the injured person had no medical doctor to state that the chiropractor was reasonable and necessary. So human error would have to be with the medical documentation of the doctors, and they are, when they're not properly documenting all the symptoms and complaints that should be there in the demand package.
Yeah, and I think that's really good to know that you need to, stay on your doctors as well and your medical care, and maybe having a family member there when you're going through any kind of procedures and things like that to ensure that that is being documented as well so that it gets implemented into the software at the proper time. Now, one other thing that you mentioned in this chapter that I thought was real interesting is you've noted that some insurance companies have a team approach to adjust injury claims. And I think that this is something really that we need to cover to talk about the different claims adjusters that are going to be working on your case. So what is the team approach, and how do we prepare for a situation like this?
Yes, the team approach to adjust injury claims. Some insurance companies have different teams you can contact in the phone queue. For example, you can contact team 1, 2, or 3, and so on. In fact, some insurance companies have stopped using telephone extensions for their individual adjusters altogether. The first person you now reach on the phone is a member of a team assigned to the specific claim. This is done so no one in particular can be held accountable for specific conclusions or actions, namely settlement claim value. If the insurance companies can eliminate the human element or human heart in the claims review process, then it can potentially better increase their profits by standing firm in lower claims payout than letting a jury trial make the decision for them. But personally, I think it's a bad approach because it becomes increasingly difficult to speak to the assigned claims adjuster on the file. And sometimes the left hand doesn't know what the right hand is doing with the team approach concept. So in my view, the team approach is really just another mechanism the insurance companies are using to be mechanical. Again, like you had mentioned earlier, take the human element out of the review process so no one can accept responsibility for the claim being handled. And also that ties into deny and delay the claim even further. So, yeah, the team approach, in my opinion, is not a very good way to go with some of the insurance companies that are using it. And not all of them are using it, but some of them have started using those more and more.
Wow, that's a really eye-opening thing to look at when, you're the injury victim and you're just trying to get somebody on the line who knows about your case. You're not exactly sure who you're going to get on the line. And,
right.
And that works, obviously, in the insurance company's favor for the reasons that you just noted.
But it sounds good. It sounds good, Greg. We have a team, right?
Of course.
But really, in reality, it's to their benefit.
Yeah, then that's you got it. You hit it exactly right there. So as we start to close up part 3, is there anything else that you wanted to touch on from maybe the insurance company side of things or from the claim adjuster side of things that could impact our case and our settlement?
It's really, I always meet my clients one-on-one. I will never delegate that duty. I've got to meet my clients so I can meet them and see how they are as a person and see how they make a potential witness for themselves eventually in case the case ever goes to trial. But really, the key to all of this and understanding with the claims adjusters is that you really need to just protect yourself medically, number one. If you're not that injured, fantastic. Just go a couple times to the doctor. You're okay. You may not even need a lawyer in that case. In fact, like I said earlier, not every case is going to need a lawyer. But you definitely should get good counsel just to make that informed decision. But effective medical care right away, and don't be afraid. If you don't have health insurance, there are a lot of good lawyers out there that can help you find doctors that are willing to treat you when you don't have the insurance. And just document everything. Remember, it's all medical-based evidence documentation for claim value today, very detailed stuff. I give my clients packets to document their interferences in their daily lives. So, be detailed, document everything, how it's impacted your life, how it affects your routine. Also document things that you do to participate in your own recovery, and that could be self-medications. That could be, you can take pain medicine from a prior injury. If it's for pain, a jury is going to find that reasonable, but the computers will find that reasonable too. So just be proactive, think outside the box, go with the flow, but report to your doctors and do what they say, and that's my best advice for all of this.
Definitely, and we really appreciate some of the tips and suggestions that you've given throughout this series. And as we close out part 3, again, have that action guide in front of you and take down the necessary notes that you need for your own case or for the case of a friend or a loved one. In part 4, Mark is going to be explaining what your attorney needs to know to maximize all the knowledge that we've been talking about in the first 3 parts. So again, we thank you for listening to part 3, and we'll see you again in part 4.